All right, well, I have 2 minutes after the hour, so I'm sure we'll have a few more join us, but let's go ahead and get started. So good morning, everybody. I'm Marty Rosendale, CEO of the Maryland Tech Council, and this is the Business Continuity Task Force Executive Insight Series. The Business Continuity Task Force, or BCTF, was formed during the pandemic with executive mentors from our Venture Mentor Service to assist company executives facing the pandemic recession. Today, we're focused on building business resilience and facing current challenges of workforce, inflation, and global economics. If you're interested in speaking with an executive advisor, go to our website at mdtechcouncil.com. The Maryland Tech Council is the industry trade association representing the technology and life science industries throughout Maryland. Together with our members, we're improving the business climate in Maryland and helping companies that save, secure, and improve lives around the globe. Before we get started, I have just a few housekeeping items for you. For now, your microphones are on mute. We will be monitoring the chat and the Q&A functions during the discussion. So please use the icons found at the bottom of your screen to make comments or ask questions. This Zoomcast is being recorded and will be made available for others to watch or listen to. Thank you all for joining us today. My guest today is Greg Stone, co-chair of the Technology and Intellectual Property Practice Group at Whiteford, Taylor & Preston. He's also a board director at the Maryland Tech Council, strong supporter of our business communities, and one of the founders of our chapters in Baltimore as well as the Chesapeake region. So Greg, thanks for joining me today. We appreciate your time and all your support of the Maryland Tech Council and our industries.
Yeah, thank you, Marty. Absolutely happy to be.
So Greg, you've got a pretty interesting background. You're an engineer, you've been a patent examiner, you're a musician. Tell us a little bit about your background. How did you get to where you are, and why are you passionate about intellectual property?
Well, fundamentally, I've really always been just fascinated by new technology, really from childhood on. You know, as a kid, just building models, tinkering with broken tools, broken radios, things like that. And I knew in high school the path that I wanted to take. I was absolutely certain I was going to be a mechanical engineer, and particularly find a way to work as a mechanical engineer somehow in the defense industry. So got to college, University of Maryland, College Park, studying mechanical engineering, became a co-op student, working for the Army at Aberdeen Proving Ground as a co-op student during undergrad, and was working on heavy weapon systems. And really thought that I'd stay in that industry long term, but there was budget tightening at the time, and that just practically drove me to look for alternatives, which led me actually to the Patent and Trademark Office as a patent examiner. And when I landed there, that was really my first introduction into the bridge between law and new technology, and really just came to learn and discover at the time that our patent system, can be used to help drive innovation and development in new technology. So from there, I decided to go to law school with really the sole focus of becoming a patent attorney. So today now, I've been in the field for 30 years from I started at the Patent and Trademark Office, 26 years as an attorney, and have really worked throughout my career to just help clients build protection around new products, new processes, services, new branding, which is really a great job for somebody that's a technology geek. It lets me just keep learning new technology. So that's why I'm really so passionate about the field.
So do you miss engineering?
Well, no, because what I'm doing now still involves me with engineers on a daily basis. I mean, as I'm starting a new project or new patent application, I'm sitting down with the engineering team and breaking apart what's in their mind, the thing that's in front of us, trying to craft a description around this great new gizmo that they've come up with in a way that a judge or a lay jury is going to be able to understand.
Right. So Greg, tell us about your practice. What does your practice look like? Who are your clients? What kinds of things do you do for them?
Yeah, sure. And first, let me do a little bit of intro of the firm generally.
Mm-hmm.
The firm, Whiteford, Taylor & Preston, is about 180 attorney general practice firm. We've got 17 offices throughout the Mid-Atlantic. But again, my practice individually is on all things intellectual property. So that's preparation, filing, and management through the examination process of new patents, trademarks, copyright application filings. We're really in all fields. Then it's developing and negotiating the agreements that surround IP. So things like license agreements, manufacturing and distribution agreements, joint development agreements, things like that. It's performing IP specific due diligence. If a client is coming up into a major M&A transaction or other big transaction, trying to make sure that their IP is well positioned for that type of transaction, then it's litigating to protect our client's interest, whether it's looking to protect the IP that they've developed by going out and enforcing their patents, their trademarks against folks that we think are copying their innovations, or defending them from allegations from third parties that their new innovation is stepping on the rights of others. And that our client base is really, really diverse. It's literally made up of everything from two-person startups to Fortune 500 companies, and it's anything and everything in between. I grew up as a patent attorney in Baltimore, where we've got that diverse client base, but we've always worked a lot with different incubators around town. So we're working with those smaller companies as they're coming up has been a significant block of our client base throughout the years, and really one that's really fun to work with, because it's still at the stage where everybody's really excited about the new technology, and so being able to roll the sleeves and dig in with them when they're still excited about it is really, really kind of cool.
Mm-hmm. So right now the times are pretty dynamic around the world, right? What are your clients? What are their behaviors right now with respect to their intellectual property? I know business resilience and continuity is critical right now. What are you seeing from your clients?
That they are as competitive and as innovative as they've ever been, and that's really from just small filers to really large, huge institutions with big portfolios. Over the last several years, I was surprised at the outset at the start of the lockdown, but over the last several years, we've really seen increased we've really seen a lot of increase in filings. People have maintained that competitive drive and that drive towards innovation. And I mean, really, it seems like as we've been moving along for the last few years, as more patents are arising, because more people are doing more filings, other members of the industry, of those industries where we're seeing a lot of filings, don't want to get left behind. So they're realizing their competition is increasing in filing. They're coming to realize that if they're going to maintain a competitive edge, they've got to keep up with filings. I really thought at the start of lockdown, as did I think many practitioners, that we really see a significant clampdown on funding of innovation and of trying to implement IP strategies, but really it's been the opposite. And 2020 was actually the busiest year I've had just for new filings in the last 10 years. And then 2021 was heavier. This year is heavier than 21. So we keep seeing that trend. It's not just filings. It's thinking about the other aspects of IP protection. It's things like we're seeing increased efforts to go out and license technology. Right. So many people over the years have developed IP portfolios that have yielded, morsels that are just sitting on the shelf. That they were going down this one line of innovation and they sought patents for it, but they never actually ultimately commercialized it. So there's unrealized value that's sitting there on the shelf. And it seems that the folks have been going back and looking at that, trying to extract more value. So we've seen increased license activity. And we're seeing increased litigation. People are maintaining that competitiveness, and we're seeing a little bit of digging in now, and really folks trying to trying to focus on shoring up protection for the stuff that they do have, the patents that they've secured. And so we have seen an increase in litigation.
So Greg, you've been doing this for a few years, and I think it's the nature of Americans to innovate our way out of difficult situations. Is this consistent with what you've seen in the past when there have been challenges? Have the patent filings gone up as a result of that innovation, that desire to get out of a challenging situation? Or is this unique? I guess my question is what you saw during the pandemic, and I guess we're still kind of in the pandemic, is that unique, or have you seen it before?
Well, there's the issue of the pandemic, and then there's the issue of the overall economic effects of the pandemic. And so from the perspective of the pandemic itself, no, I think that's the innovation response that came about was a little bit unique, because we're all in a different world now, and there are different theories surrounding what has really led to those increased filings resulting from the pandemic. Some of it is thought to be, well, we've got this now distributed workforce, and with the distributed workforce and some people leaving jobs and not coming back, there have been some cost savings.
Mm-hmm.
Among some companies, and that might have driven some of the increased filing, just having bigger budgets to devote towards more strategic planning from a business perspective. And I think it's just been a little bit of a new philosophy addressing business models and having IP wrapped up in that mix, in just driving this new thought of hey, let's put some real effort towards building out our IP portfolio. But then on the economic front, certainly some folks have been more challenged in the lockdown environment, and that really has pretty much tracked what we've seen in the past. You generally have, among certain sectors, increased filings. The smaller filers will at times tend to drop off in economic downturns, but you'll have it's not really a change in number, it's a change in quality and direction and strategy that folks are employing when they're going down the IP road, if they're facing just economic challenge. The smart ones are staying in the mix, are continuing to make the filings, and just really trying to build that strategic approach of going in and looking at what should I file, where should the money be going, in what country should I file, is this technology segment that we're developing in-house right now, does it really have commercial legs to stand on? If not, maybe that's one that we put on the shelf and concentrate all the budget that we otherwise would have spent on this one particular line that we know we're going to extract commercial value out of. So really having that more strategic sense. But by the raw numbers, no, that we haven't seen drop off. An increase in certain sectors is something that we've seen before. Not sure where we'll go over the next 12 to 24 months, but from what we've seen right now, it's remained really, really strong. Yeah. And I think that's a good sign for at least our local economy.
So Greg, when you were describing a second ago what you're seeing during the pandemic, you also mentioned increased litigation, and that surprised me. I mean, I wasn't surprised that our businesses, our innovators have been innovating to get through the challenge. But you said you've seen an increase in litigation. Can you talk about that a little bit? Why do you think you're seeing that increase in litigation?
There are lots of theories, but really, I think fundamentally, it's a concern over where we're going to be 2, 3, 4, 5 years from now. Right? If people are from the litigation perspective, people are using it as a tool to dig in, to dig in from where they were before with maybe I'm trying to look for an appropriate term to use.
Sure.
Not a careless or worry-free approach previously, but really trying to say, hey, if we do experience a downturn and our business revenues drop, if we then face competition that we would have been able to quash earlier, the competition is just going to eat our lunch. And I think it's being driven more by the concern of where we might be economically overall in a few years. That's telling people today, I need to go out and secure my spot in my marketplace and ensure that if I've got a nice segment, a nice box of exclusivity out in my marketplace, that I'm doing all I can to lock up those rights. And maybe you're using litigation then from that perspective to not necessarily shut down other competition, but get longer term agreements in place through licensing arrangements that would come out of settlement of litigation, so that you've got your partners well defined. You've got your economic landscape well defined as we go into perhaps a more questionable economic security environment over the next few years.
So Greg, let's talk about this for a minute, because I think this is something that everybody's got on their mind, right? What's going to happen in the next few years, and then how do I secure my competitive position? So litigation, ensuring that you have strong protection of your patents is one approach. What other advice do you give your clients? How should they be viewing their intellectual property portfolio today to make sure that they're securing their competitive position tomorrow?
It's something that we've seen in previous downturns, and it's really a matter of fundamentally being more strategic in the way that you approach IP management. So it's not strategizing to drop money from the IP mission of the company overall. It's trying to figure out where the funding should be put, in order to build out and maintain protection over an IP portfolio. So for instance, for smaller companies that are going to be looking for funding in an economic downturn, it's more important than ever to ensure that whatever IP is appropriate for what that company has developed, that you're making strategic decisions. Is it patent worthy? If so, am I putting my patents towards the things that are going to make real commercial sense? Is it not patent worthy? Is it stuff that's protectable by trade secrets? If so, do I have a reasonable program to protect those trade secrets in-house? Because as the funding source comes in this more competitive environment, a VC group is going to be way more discerning over where they're going to put their investment dollars. And when they're more discerning, they're looking at these strategic aspects, the real value that's embodied in the company's IP. So just for the startups that are going to be looking for funding, or early stage companies that are going to be looking for funding, it's more important than ever that they're going through and making sure that they've identified those pieces that can be protected, and for the pieces that can be, that they've taken the appropriate actions to protect them. So that's one. Just looking at it from the perspective of the early stage companies, and then for companies that have existing portfolios with stuff that is sitting on the shelf that's not been commercialized, it's going through and auditing those items that the companies have maintained to say, is this something that there is any commercial value for, even if it doesn't fit our current business goals? Because if it is something that has commercial value for some partner out there, let's get it licensed out. So we'll recommend to folks that have larger portfolios, some of which have nothing to do with anything that's currently commercialized, go out, survey the competition, or maybe not even the competition, but the commercial sectors that surround some of those facets of your IP that you just haven't commercialized, and see if there are partners out there that would have interest in licensing out that IP. And when things are great and you're just chugging along, you're not worried about the stuff that's sitting on a shelf and nobody's paying attention to it. But as the belt gets a little bit tightened, that's a great additional source of potential revenue that a lot of times companies will ignore. So we'll advise that they go out and look to try to commercialize that stuff. And then I had mentioned, earlier, just looking at the approach to a major transaction, like an M&A transaction. A company might be that's already thinking, the senior executive is thinking, 6-7 years from now, I'd really like to have an exit. Well, if we're belt tightening over the next few years, but I still think that I've got solid value right now, well, maybe I'm moving up that timeline because it's just too questionable of where we're going to go too far down the line. If that's the case, those folks, anybody that's looking to speed up a transaction, needs to make sure that their IP house is in order well before they're getting to the negotiation table.
So,
but really, fundamentally, it's just taking that more strategic view towards how they're managing their IP.
So I want to come back to fundraising and transactions in a minute, because I think that's on people's minds right now as well. But let's come back to strengthening the IP portfolio for a second. You talked about IP that might be on the shelf within the company. But I've often thought about, the fact that we have all these national labs. And, I'll go back to a conversation I had with someone at the Department of Energy that I think was about three or so years ago. And he told me that they had 19,000 patents in the Department of Energy that nobody was using. Do you ever advise or assist your clients in looking for additional IP, from those labs to strengthen their IP portfolio? Because I think often people struggle. It's an interesting concept. But how do you search, these libraries that have tens of thousands of patents and find the one or two that are going to strengthen your portfolio?
Well, that's one of the challenges, and the other challenge is just, the companies having the manpower to go out and search this wealth of technology that's already out there, and it's not just the federal labs, right? It's the federal labs, it's universities, it's other smaller companies, or even solo inventors that have invented stuff and have never done anything with it. They got a plaque that they've hung on the wall, and they've never extracted $1 of value out of that investment. So there's big challenge of just having somebody at the company have the resources to go and spend the time to do the research. But another challenge, to be quite blunt, is some of the challenges that lab and university tech transfer offices have in getting their technologies out to the marketplace, getting them promoted, getting folks, aware of what is out there and available for licensing, and then taking it from there into a discussion that will lead to commercially reasonable licensing terms. There are times where we're representing an early stage company that's trying to get a license from University X, and they're going into the discussion. They don't have any revenue yet. They don't have a lot of resource to put on the table, and yet the terms that they're facing for taking the license just at times can tend to be a bit unreasonable. And obviously, there are universities and there are labs with with fantastic tech transfer groups that have great terms, and they do a great job of getting the technologies out and into the marketplace. But there are others who aren't, and that creates some of the challenge. I mean, do I recommend to clients that there is a wealth of IP out there, not for the taking, but for appropriate commercial licensing? Yes, absolutely. But yeah, it's still a challenge to just isolate the ones that are going to be material to what you're working on. And then again, finding the ones that you can get under commercially reasonable terms. It's funny, Marty, because I get, probably every other day, I will get a new listing of some new clean energy, just a clean energy field related technology that is available for licensing in an email blast from DOE. And there's just a wealth of stuff that's out there, and people do have trouble accessing it.
Yeah, I know, and I know a number of people have looked at ways to make it easier. I don't think anyone's come up with a solution yet.
Not yet, not that I've seen.
So let's come back to transactions and fundraising. You brought that up a couple of times during the conversation. Right now, given where the economy might be headed, there's no certainty where it's headed, but given where it might be headed, I can tell you that the advice that I'm giving founders and entrepreneurs, and I know my colleagues, the CEO advisors and others are telling founders that if you're thinking about an exit right now, then you better do it, because the opportunity may not be here 2 years from now or 3 years from now, and it may take you 18 months to facilitate that exit. So we're talking about expediting exits, right? And when you think about the intellectual property, and I told you earlier this morning, I read a PitchBook article that said that VCs are looking more towards real assets because they feel that they can protect themselves. Now, they were talking about real estate and other things, but it seems to me that a strong intellectual property portfolio is also going to be attractive to venture capitalists and investors. So when you're advising companies that are looking to make that exit, or they're thinking, I'm kind of ready for the exit, but I'm concerned that I won't be able to exit 2 years from now, 3 years from now, when I know I'm going to be ready. So I want to expedite it and do it now. Now they're not ready because they haven't thought of it before now. They've got to get ready. What does that look like? How do you work with them, and what advice do you give?
So if we are fortunate enough to have the conversation before they actually have somebody courting them, for that transaction, then fantastic. There's a lot that we can do for them. It starts with just auditing their IP, going in, looking at, okay, well, what have you done in the past to protect your innovations? What stuff is sitting on the shelf that maybe you've not commercialized and developed protection around? Do you have lots of what you would consider to be trade secrets? How are you treating them? Do you have appropriate protections in place? We call it an IP audit, but we would go in and perform an IP audit at that early stage to try to ensure that all the steps that should be taken have been taken well before they get to the table. I mean, it's really a very large collection of issues. Again, for patents, just not only have they been obtained and maintained, but have you covered the right things? Have you covered the things to give a scope to the patents that competitors are going to, or that an M&A partner is really going to be interested in? It's something that has commercial value. So in a market segment that the M&A acquirer is going to say, that's a market segment I want to go into. If not, is there opportunity for us to maybe do additional filings to go down that line? From the branding perspective, have you taken the steps necessary to wrap appropriate trademark protection around the different brands that you have out in the marketplace? If you haven't, and we're early enough, there are filings that we can make at the trademark office to to ensure that we've got adequate protection wrapped around the brands. I mentioned trade secrets. If you've got secret formulas, do you have literally data control processes in place? Things like requiring your employees to just access their systems by way of, well, today, things like at least two-factor authentication. Have information locked up, requiring passwords on secret documents to literally have the information locked up and inaccessible to folks that are not supposed to have access to it. And also on the employee front, this is one that we see with I would say disturbing frequency on the employee front, the issue of sewing up ownership of whatever the IP is long before you get to the question of, well, what IP do you have, as the acquirer is looking at you. We've in a number of transactions come up against a client who has patents. They've actually gone through the whole process, and they've got a couple of patents that for stuff that's been developed by a tech team in-house. And it's really broad. It's great coverage in the marketplace, but they never secured formal assignments from all of the inventors to the company. And when we've seen this issue arise, it's kind of universally the understanding and expectation of the owner of the company that I paid these folks to do this development. They were all employees while they were here. I own all of that stuff, and I own it automatically. I've heard of this work for hire doctrine. I know that I own this stuff. And so it doesn't matter that one of my 6 inventors that's listed on there has left and gone to another company, and they left because of some unpleasant claim, and we've got no relationship with that person anymore. It doesn't matter because I own it from work for hire. Well, work for hire is a doctrine under copyright law. It is not a doctrine under patent law. A lot of people are surprised to learn this. Patent rights are owned by the inventors, unless there is something that disposes of their interest and gives it over to the employer. So we handle that by way of an employee invention agreement, or just an assignment agreement if all employees haven't signed that employee invention agreement. And we get an assignment signed by the employee, assigning it over to the company. But the worst case scenario is you've got this patent issued, you go into an M&A transaction, the other side is doing due diligence. They say, hey, we don't see assignments for your 6 inventors. Can you go get them and file them? And you find out that one of the 6 is gone under a negative situation where you're going to try to chase them down, but it's going to be a real battle. That can be a real challenge, and one that we try to fix well before anybody in that case would get to that M&A negotiation table.
So this is really interesting, Greg. I hadn't thought about this in a while, but a lot of employment agreements have a clause in there that says, while you're an employee of this company, if you use company time, company assets, and you invent something, the company will own it. Is that enough protection? And how important is the wording of that clause in that employment agreement?
So that type of document, yes, that is sufficient. That in general, nonetheless, when you do a patent filing, you're going to have to come back with a separate document. So you want that employee agreement to build in an obligation. The employee will not only automatically sign, but they will sign additional papers that they have to confirm that ownership over to the company. But generally speaking, yes, that's the right approach. That's what a company wants to do. But it really depends on what the words are in that provision. It can't just say anything that you do for the company is work for hire. We've seen that issue a number of times. If it just says anything that you do is work for hire and we will own it, that's not enough. It has to be for written original content that you develop for which a copyright interest might attach, we all agree that is work for hire and we own it. For inventions that you develop, you hereby agree to assign over to the company all right, title, and interest in the invention and any patent rights that result from it. So it really is important to have proper verbiage in those provisions, in those agreements. And really, the earlier they say, that should be an employee intake process, that the company has a form that they would use. And so for any new employee that comes in, and certainly any new employee that is in the technology function that comes in, signs that document day one.
Mm-hmm. Interesting. And even with that document, it sounds like there still needs to be a formal assignment. The employee is agreeing to assign it, but that assignment still needs to take place.
That's right. And really what the original agreement is doing is shoring up your position in the event that, okay, today something is half invented, one of the employees leaves, it gets finished a month from now, a patent application is filed, but the employee that left nonetheless had some inventive contribution to whatever that invention is. That original agreement now has significantly strengthened the case on the part of the employer to go and require that departed employee to come back and sign this form. Look, you agreed that this is a contract that we have with you, and you have to sign this additional document.
Okay, interesting. So I just want to remind the audience, if you have questions or comments, you can use the chat feature or the Q&A function, and we'll open it up for questions in just a few minutes. Greg, I want to come back to trade secrets. I hear a lot from companies about, they are protected because they have trade secrets. Now, typically their attitude is, well, I'm just not telling anybody what they are, so they're protected. You talked about things that can be done. Dig in a little bit deeper. What if a company has trade secrets or believe they have trade secrets? What are the kind of steps they should be taking to protect that?
Okay, so first, we should define a trade secret. A trade secret is essentially information, and it's any information that has independent commercial value. So that could be design specs, it could be customer lists, any information that has independent commercial value. But for it to constitute a trade secret, that valuable information must be the subject of what we call reasonable measures to maintain its secrecy. So what are reasonable measures? It really depends on the context of what the information is, what it's used for, who has access to it. So things that a company can do for any information that it deems to be a trade secret. Number one issue is on that employee intake. When employees are coming in, they need to be educated that the company has and relies on trade secrets for its value in the marketplace. That's why we are going to have you sign a non-disclosure agreement. By this agreement, you are bound to not disclose anything that is identified to you as a trade secret. Likewise, with partners, folks come into the facility and are going to have access to or be near places where they might see certain information that you would deem to be a trade secret. Then the visitors should be signing non-disclosure agreements. Any agreements that you have with third parties, things like development agreements, things like manufacturing and distribution agreements, they might entail a disclosure of certain facets of your confidential information, your trade secret information. Those have to have really strict designs over how the information can be used, the limitations on what they can do with it, the way that they should store that information. And then you've just got the technology infrastructure that folks today need to be employing to reasonably protect information. I mean, everybody is storing things digitally today. So it really is the practical things like requiring employees that would have access to that information to have a user login, that they can only get in with a password, that it's restricted access, that files are stored by way of by way of password protection and things like that. And then importantly, on employee departure, when they leave a company and go somewhere else, there should be an exit interview and a document that is signed by that exit employee saying, I hereby confirm that all trade secret information that I've had access to will not be disclosed to any third party. The time at which a trade secret issue blows up is typically, certainly there's plenty of trade secret theft through corporate espionage and those kinds of things. But the most common situation is former employee of company A goes to competitor company B, and suddenly in 6 months, competitor company B has a competitive product that is employing technology that looks mysteriously very similar to company A. At that point, your only resort is then to try to take action against company B, saying, we believe that our employee has disclosed our proprietary trade secrets and that you have used them in this new product. As long as you get there early enough, you can stop that activity. But number one, if you haven't taken the steps to reasonably protect, to reasonably lock up the information, then you're not going to have those protections, and that information is free for anybody to do with whatever they want to do with. But if you have taken those protections and you get to that entity early enough such that they haven't really let the cat out of the bag and disclose the information to the public, then you can keep that information still as a trade secret and hopefully, collect whatever damage has been done against that company. If you're slow in enforcement and they've already let the cat out of the bag, then yes, you still have action against them for the damages that you've incurred. But the cat's out of the bag and everybody else now has access to that information. You can't claw it back.
Interesting. So first of all, looks like we're going to have a lively Q&A. So I'm going to take us to the questions in just a minute. But I want to pursue this a little bit further because this has become a topic that I hear quite often, about trade secrets. So if that employee does divulge the trade secret to a new employer, it seems to me it would be difficult to prove that company didn't discover this on their own. And so I'm curious how often the company that had the original trade secret, how often they prevail and win those lawsuits.
Well, it depends on the strength of the claim.
Mm-hmm.
I mean, but there's an investigation process that one would go through in advance, right? So it's you can do things like sending a letter to the company that you suspect has had inappropriate access to your trade secret information, and ask them, give us the details then of how you developed it. Now, in all likelihood, they're going to balk and say, well, no, we'd be disclosing our trade secret information. And then, you can enter into an agreement between those two parties to have confidential disclosures, to have perhaps just experts look at the information to make the conclusion of, did they really do it independently, or does it look like they maybe had access? So you can vet that before bringing a formal action. And obviously, if the other side clams up and says, no, we're not willing to disclose this to anyone, regardless of whether or not we have a really, really tight non-disclosure agreement and you're not going to disclose our trade secrets, well, that's going to be pretty suspicious. If they've got something, that your technologists really think could not have been developed or implemented without access to your secret sauce, then you've got reasonable grounds to assume that they have in fact been using it. And then when they won't come to the table to say this is how we've done it, well, then you're going to be more likely to file suit. I mean, it is a little bit of foggy crystal ball that you're looking into at that point, but one would reasonably ask in that situation, well, if you really didn't use our own information, then why can't you just show us or our third-party expert who's not going to tell us anything but the final conclusion, how you came up with this? And this is also an important issue for employer B, who brought in that employee. If you're bringing in somebody that might raise this type of issue, you're going to want to cordon them off from any project that you're working on that is directly competitive to company A, to make sure that this issue doesn't arise, and to make sure that you've got a very clear, clean story of when you developed your new tech. This employee that came from company A had absolutely nothing to do with it. So for the fair playing company B, it's something that they should likewise be thinking of, just to shield themselves from a potential threat of trade secret misappropriation.
Interesting. And it sounds like design history files and records are really important in these cases.
Absolutely. So much of which now, again, is digital, and with for forensic technology today, all of that is ultimately discoverable. So yeah, having really, really clear documented records, historical records showing the development process are absolutely critical.
Interesting.
Very valuable tool in discerning who did what.
So Greg, we've got a number of questions. Before I start diving into those questions, is there anything that we haven't talked about today that you wanted to cover?
No, I really think that we've hit all the issues. I just want to kind of set up the major takeaway of, and as self-serving as it sounds, increasingly we see companies being challenged because they simply did not address the issue of IP early enough. And a lot of that is just not understanding the complexities of the intellectual property laws in the United States. But the earlier that you address what your IP rights are, what they should be, what is your ownership story appropriate, you have all the boxes checked, to ensure that you really have locked up all the rights that you think you have. The earlier in the process that you can do that, the better. If you're launching new products, new services, new branding, the earlier in the process that you can look to wrapping some protection around them, the better. And that's whether you're using outside counsel to do it, or if you have a team internally, you should have somebody devoted to the mission of evaluating IP implications for new products and services just as early as you can.
All right, great. So we've got a number of questions here. I'm not going to take them necessarily in order because I think they might make a little sense if we do it out of order. But one of the questions has to do with the conversation that we had, Greg, about employee agreements and agreements to assign intellectual property. And the question here is, if that's addressed in an employee handbook, and the employee signs a document that they've received, read, and understand the employee handbook, is that sufficient protection?
It depends on the language of the statement that they've signed, right? Usually, for purposes of an invention, in which case we're then dealing with patent rights, that's not enough. You want the language that they sign to say, I hereby confirm that anything that I come up with, essentially, this would be wordsmith with appropriate legalese, but anything that I come up with in the scope of my employment during the term of my employment is the property of my employer. And signing, acknowledging that affirmative assignment statement. I mean, but that said, it is always best not to rely simply on a statement in a handbook. It's great to have the policy spelled out, in the handbook. It's adding ammunition to the position that the employer owns all rights outright. But really, the best practice is having them sign a separate employee inventions agreement, whereby that is affirmatively spelled out, because even with that specific language that they could sign in a statement in a handbook, it's not going to have other provisions. It's not going to be fully fleshed out the way that an appropriate agreement should be fleshed out.
Yeah, I mean, I've seen it covered redundantly, right? I've seen Partnerships where it's covered in the operating agreement. It's also covered in the employment agreement. I've seen it covered in the employee handbook. I know auditors often advise that employees should sign their handbook every year just to reaffirm those things. I mean, I've seen it handled a multitude of ways, but it is something that's really important.
Yeah, and the employee handbook can change, over time. Which then raises the question of enforceability of a term that was in the original one that they read. Whereas if you have an agreement at the outset, the terms of that agreement aren't going to change in all likelihood. Their obligation to assign is going to remain the obligation to assign. So all the more reason to have a separate agreement. Yeah.
So this next question, Greg, I'm not sure you'll have an answer because you're not a banker, you're an IP attorney, but the question is, how do you assign value to a patent, especially for an early stage company where the value of the company is so closely tied to their intellectual property? How can you assign value to that patent?
Yeah, and there are experts out there that will perform valuation analyses on a patent, based on the business side. Okay, well, what's the what's the market for the technology that you're covering here? Who are the competitors? What is the extent of their patent portfolios? Is the thing that is covered by your patent something that is has commercial value, or nonetheless is it a small bell or whistle that is added to technology that's already out there, and maybe you're going to struggle to practice it, to actually put your own product out in the marketplace, because there are still some foundational fundamental patents out there that are so broad they're still going to cover whatever your innovation is. So it is a little bit tough to say, particularly because that is something of a business and pseudo accounting function. But when we talk about value, really one of the most fundamental aspects is simply what is the scope of the patent. And when we're talking about values of patents, what is the scope of the patent, and how broad of a territory does it cover? And that's going to be determined by what specifically is recited in the claims of the patent. Again, are they really, really broad, or are they very narrow bells and whistles? If they're narrow, the value is going to be less. If they're very broad, the value is going to be much higher. Typically, the scope's going to fall somewhere in between, those two extremes, and it's going to vary, from not only technology to company to company, but really from invention to invention. Just how crowded is the space that's out there, and what are you able to carve out in the scope of the claims of your patent is going to be the fundamental driver of what the value of that patent is.
So Greg, the next question takes us back to the conversation of patent versus trade secret. And the question is, how does an early stage company determine, or how should they determine, whether to pursue a patent or to protect something as a trade secret? I've heard company founders say to me in the past, well, if I file a patent, it becomes a matter of public record and people are going to see what I've done. And so I want to keep it secret. How do you advise a company and a founder to make that decision? Yeah,
well, I mean, that's a good mental process to go through. Just what you said right there, Marty. The patent puts the subject matter out into the public domain, and it gives everyone a template to go out and make and use whatever that invention is. For whatever the technology is, the inventive team really has to look from a technical perspective. Once I implement this, how hard is it going to be for someone else who sees what I do to go back and reverse engineer it? If they have legitimate, legal, proper access to see what I'm doing because I've made it commercially available, or because I put it out there and I don't have restrictions on how it might be used, if a party out there can see the functionality, let's say it's a new piece of software, which is its own animal that carries difficulties in patenting today. But nonetheless, let's say it's a new piece of software with this amazing new algorithm that dissects this data that you've collected from a unique set of sources and processes it in this great new way through this algorithm to give real insightful intel. If the display of that intel in and of itself is going to tell people how it is that you came about with the calculation to present that intelligence, is such that somebody's going to be able to easily reverse engineer the process for you getting there, then trade secret's not going to do you a heck of a lot of good. And if you had patent protection for whatever that is, the patent, well, it's only going to last for a limited amount of time, 20 years from your original filing date. The patent can give you the right to exclude anyone from making, using, selling, or offering for sale whatever it is that you've patented. So from that perspective, a patent can be way more valuable. But if you've got something that is clearly very, very difficult or maybe even impossible for a competitor to figure out, and you take appropriate protections to lock up whatever that information is, that could be saved as a trade secret forever, for as long as it remains a trade secret, as long as nobody else figures it out. So you really have to look at it from the technology perspective. How hard is it going to be for a competitor to be able to figure out what you do and how you do it, and to thus be able to reverse engineer and let that drive the decision of, do I want to go down the patent road or do I want to go down the trade secret road?
And it's interesting. Earlier in my career, before I became a microbiologist, I was a tool design engineer, and I worked with a gentleman who built an amazingly huge company around. All he did was reverse engineer kitchen appliances, and then rebuild them, and he built an amazing company doing that. So I understand what you're saying.
And those could have been systems that were patented, but nonetheless, patents expired, 15, 20, 30 years before, and he's absolutely free and legitimate in going out and doing that.
Yeah. Well, we're not going to get to all the questions, Greg, but there is one that I do want to ask you before we run out of time, and that is, how much of a company's budget should be reserved for strengthening the IP portfolio?
Oh, certainly all of it.
I knew you were going to say that.
How much of their budget should be reserved to protecting? Well, you can't have the protection without the innovation. So you first got to be budgeting to have the appropriate resources there to be creating the IP in the first place. I can't say that there is any magic number of a percentage of revenue that should be devoted to the IP mission. And I really think the complexity of the IP portfolio that would need to be developed is going to vary from company to company, depending on what the technology is, what the market is, and who your competitors are. There are some companies for whom IP is it. They're never going to have a product or that they put out in the marketplace or a process that they themselves implement. They are just an idea development shop that patents, that undertakes patenting of new innovations. And if that's the case, they're going to have a huge chunk, presumably, of their overall budget, devoted towards that development of their IP portfolio. But for smaller companies, it's an important function, but it's not the be all end all. You got to keep running the business. And really, it's a matter of, I would say, just taking the strategic, analytical view of what the pieces of new technology are, figuring out what makes sense from an IP perspective to wrap around it, and then budgeting from there to implement whatever that strategy is.
Great. Greg, thank you. So we just run out of time. And clearly, I'm going to have you come back for a deeper conversation, because we've got about 5 questions that the audience has asked that we didn't get to, and I've got about 5 questions on my sheet here that I didn't get to that I would love to hear the answers to. So it would be great to have you back and have a deeper conversation. But I want to thank you so much for your time. I want to thank you for all your support of the business community throughout Maryland and the Mid-Atlantic, your support of the Maryland Tech Council. And this has been a great conversation. Thank you.
Absolutely, my pleasure, and thanks to all of our listeners for attending.
Great. And just to remind everybody, this has been recorded. It will be posted on the Maryland Tech Council website. So if you know anybody that you think would benefit from listening to what Greg has to say, it would be great if you referred them to mdtechcouncil.com. Thank you all for joining us today. I really appreciate it.